Mr. Neely,
defined by
Mr. Neely,
persons.
I need you to talk to me, not to the people. Talk to me. What would you like to do today? Would you like to plead not guilty?
No,
You would like to plead innocent?
innocent, yes.
Okay, I'm going to treat that as a not guilty plea. It's substantially the same.
Probably won't be here till about between 9 and 9:30. Is that all right? Again?
We're not off the record. We're done with your case.
Yeah, I'll be off the record completely.
Number 42, Mr. Neely III.
Yes, Neely the third, and it's self-represented, not pro se.
Okay, one moment, sir. Okay, this is 25 CR 6861, People versus James Neely.
Kristen Lilly for the people.
It's James Curtis Neely the third for,
Okay, I do show Sean McCarthy's on this, but you're representing yourself. Is that correct, sir?
awarded self-representation by the state.
Okay, we're just going to remove Mr. McCarthy as attorney of record and note.
And can you remove any of his filings? For I've never been served with any copies of any of his filings.
I can't remove filings from the court record, but I can remove him as attorney of record so that any filings will go directly to you, okay? I suppose we should make sure that we have accurate contact information for you. Let me see, okay. Yeah, I wouldn't say it on the record because it's being broadcast, so.
Yeah, recordings of proceedings for the Chautauqua Charter. I know it's.
No, but I just mean it's like being broadcast over the internet. But we'll get your updated mailing address. That means, sir, that any pleadings that people file and or any orders the court issues will then go directly to you. Okay, sir?
And there's the first bond that was issued.
Okay. What are we doing today?
Your Honor, just a little bit of background on this case. Mr. Neely III's cases have been pending in the preliminary hearing courtroom for quite some time. We did go to preliminary hearing at the last court date. The case was, of course, bound over. This is his first appearance in district court. I have spoken with Mr. Neely a few times. Our conversations, candidly, we've not made a lot of progress. I would just ask the court inquire of Mr. Neely if he would like a continued arraignment to continue, if you'd be interested in hearing a plea offer and discussing that with us. If he is just interested in pleading not guilty and setting for trial, that is an option as well.
For arraignment, the plea of innocent remains.
Sorry, I can't hear you.
Plea of innocent remains for arraignment.
Okay, so a couple things. You have a couple options today. One is to continue the arraignment, which just means you're putting off entering a plea of any kind. Or the other option would be to, because we're at the arraignment stage, you can enter a plea of guilty or not guilty. Those are your options.
This is more than the first time that we've been in this district court. For once, you've already tried to argue competency where I was awarded self-representation and competent to stand trial. Now, this is an arraignment 188 days after the arrest. I'm still waiting for the original arrest warrant to be issued. As you said, my name was James Neely on the file. The bond says James C. Neely. Yet again, another deceased person, James Neely, is not the full legal name. Neely III, James Curtis, should be what it is on the appearance bond. As you wrote here in pen that you said you would update it, so it could say James Curtis Neely III.
Mr. Neely, I need you to talk to me, not to the people. I'm trying to figure out what you wanted to do today.
You just argued that we've tried to speak outside the courtroom and stuff like that, and it goes nowhere. So this is compromised by the compromise that I was trying to tell you about back.
Mr. Neely, talk to me. What would you like to do today?
The plea of innocent remains.
Would you like to plead not guilty?
No.
You would like to plead innocent?
Innocent, yes.
Okay, I'm going to treat that as a not guilty plea. It's substantially the same.
That is by you.
Okay, so I'm going to accept and enter the not guilty plea. I'll make a finding that speedy trial is, thank you, December 25th, but because that's a holiday, I'll make a finding that speedy trial is December 28th of this year. Sir, the next step after a not guilty plea enters is to set a few court dates and set deadlines for the filing of motions. Do you know whether you'll be filing motions?
I have filed multiple motions, multiple writings while I was in jail since December 20th, from the original charge from when it happened on December 20th for the assault on a peace officer. I have speedy trial in. The county already told me 6 months. That was back in January when she first tried to argue competency. Now it's 188 days today after already serving over 90 days in jail prior to my bond. That is way past speedy trial, December 25th.
Okay, I'm not sure if you're raising the issue that there's been a violation of your speedy trial, but to the extent that you are raising that, I'm going to deny it. The speedy trial clock begins ticking once you enter your not guilty plea. That just happened right now, and I've set your speedy trial deadline. So we'll set a jury trial date within speedy trial. But right now, my question for you is, do you anticipate filing any additional motions?
Correct.
You do, okay.
Yeah.
Does 21 days, is that enough time for you to get your motions filed?
Yeah, a restorative motion right now being filed for all my writings since December 20th.
I'm sorry, I didn't hear that last part.
A restorative motion since December 20th, since the arraignment.
A restorative motion?
Yes.
Okay, you'll have to do that in written form, sir. But
It's in writing within the county already. Everything should already went back to the state and then it went to the district. So now the district clerk should have everything on file as we originally started.
So, Mr. Neely, all the things that you filed previously, the Judge Moses has already issued orders on those. So those are deemed completed. I'm going to set a deadline. If you have additional motions that you want to file, the parties have 21 days to file those motions. The deadline for filing those motions is July 16. Does that work for the people?
It does, thank you.
Does that work for you, Mr. Neely?
Matters of practice and of other courts, may I have all of records that they have? I have yet to receive any denial of any of those motions.
I think you can go to the clerk's office downstairs and request documents from your court file.
I have already. They said they're giving me the runaround.
What did they say?
From the district clerk to the actual county clerk, they say I'm getting the runaround by you.
By what? The district court clerk's office told you that the DA was giving you the runaround?
Yes.
Okay, I don't know where that's coming from. The clerk's office has the record, the court record in this case. The district attorney doesn't have anything to do with the court record. So if you want documents from the court record, then you need to go to the district court clerk's office. I don't know if maybe you're talking about discovery. Has he picked up discovery?
He has. We did bring his discovery at the last court date, the preliminary hearing. So Mr. should have all of the paper and discovery and discs
Okay.
that was served to him in 3H by the DA's office.
Are you talking about missing discovery or are you talking about
Yeah,
court documents?
Discovered from the state.
What do you believe you're missing?
The term felonious is, you put somebody in a hospital or you harm them in a manner of such. So I'm waiting for all of the officers' hospital records, fingerprint IDs that allow you to identify a person or his other persons if it's a, organization or anything like that. That's what I'm waiting on.
Okay, are there medical records?
Fingerprints, medical records, experiments, photographs, testimony, disposition of all
Hold on, sir.
witnesses.
And Your Honor, this is an assault on a peace officer charge. The basis of the charge is that Mr. Neely applied physical force. There is no allegation of SBI. We do not have to prove SBI. I do not believe the deputy received any medical treatment, so there are no medical records.
Okay.
Can I have a copy of the original warrant for arrest for holding?
You can go to the clerk's office. That's a document that's contained within the clerk's office, if there is one. I don't know if it was a PC statement or an arrest warrant. All the documents in the court file, sir, you can get from the district court clerk's office. Discovery is obtained by the district attorney's office, but those are two separate things.
Is this a state matter or a local matter?
You're charged in state court.
So the state clerk should have all evidence
The
then, correct?
district court clerk's office has the court record. The Denver district attorney's office has discovery.
Court record. And then is there any recordings of proceedings in this matter?
Well, everything's being recorded. If you'd like to order a
Outside of the courtroom?
outside of the courtroom,
Yes.
not that I'm aware of.
No telecommunications, no infrared, no license plate, no axon
Sorry,
database?
sir, Mr. Neely, if you're talking about discovery, So if you believe that there's information in discovery, meaning police reports, anything related to the investigation of the case, you can make a request for
Time
discovery.
and date, yes.
But you have to identify specifically what it is that you think exists. You can make the request of the plea,
Specifically, no.
and
I'm
then,
not the one who's being, you guys are the ones using this evidence against me. So whatever evidence you guys have against me, I'm allowed to see, right?
yes.
Correct?
And I understand from the people that it's been
What I need from the
provided,
state then,
that it's been provided. And if additional discovery comes in,
full judicial records, not
The-
discovery, judicial record.
anything in the judicial record is contained in the court file.
Okay.
Okay. Anything further on that?
No.
Okay, so we're going to set a disposition date and a motions hearing date.
The defendant's presence must be there too.
Pardon me?
The defendant's present must be there for the disposition.
Yes, it'll be a condition of your bond.
Can I have a copy of that too, then?
A copy of what?
Bonds, the summons that you're issuing for the disposition?
I'm not issuing a summons. I'm going to continue your bond.
Can I have a copy of the actual bond and undertaking that you are going off of versus?
Again, that's contained in the court file. You can get it from the district court clerk's
Thank you.
office. For the setting of disposition, does July 23rd work?
I can accept that date.
Does that work for you, sir?
Yes, what time?
That'll be 8:30.
Probably won't be here till about between 9 and 9:30. Is that all right again?
We do July 30th. Well, we're going to set two dates. One is a disposition date and the other is a motions hearing date. And I'll tell you what those
Okay.
both are. I just want to get them set. Does that work for both parties?
I can accept those dates.
July 30th and July 31st at 8:30 a.m.
Well, I'm going to do 1:30 for both of those.
Sounds good to me.
Okay, disposition is scheduled for July 30th at 1:30 PM in 5D. Motions, if they proceed, will be July 31st at 1:30 in 5D. Sir, at this time, your bond's continued until both of those dates. On the disposition date, if you would like to accept a plea, you can do it on that date. You don't have to accept a plea. It's your decision.
Okay.
If you or the people have filed motions and there is no disposition on the 30th, then on the 31st at 1:30, the motions will be litigated. Does that make sense? Yes?
Disposition of the docket almost in a sense, yes.
I'm sorry, I can't hear you.
Close to disposition of the docket, yes, for journal entry, yes, I understand.
Okay, and you understand the motions will be litigated the following day if there is no disposition?
Well,
Yes, okay. Anything further on setting of those dates?
21 days,
21 days to file your motions. And I think it makes sense to go ahead and set the jury trial, but anything additional on the motions, dispo, filing deadlines?
Not from the people.
does that have any reflection on 14 days to 28 days within any arguments or anything that I have within that motions?
I'm not sure.
July 31st. Well, 21 days, usually you have, after the 28 days trial set and everything like that, 21 days, you have to file all your motions and everything like that for, pre-trial, everything, reciprocal discovery, everything like that, right? Correct? So then the additional, 8 days, they have to return any, filings or anything like that. So,
The people, both parties can file a response to any motion that they want. There's no deadline for filing the response, but all initial motions have to be filed 21 days from today, and that deadline is July 16th.
so this is different from a pre-trial order then?
Yes.
Okay.
Okay, anything further on those settings before we move to the jury trial?
Not from the people.
Anything more before we move to the next setting? Okay, all right, how long do the parties think for the jury trial?
I anticipate testimony shall be pretty quick. I believe the people would only be calling about 2 to 3 witnesses. I would be asking for a 4-day jury trial just out of an abundance of caution, timing-wise.
Let me see.
In this matter prior with the county courts, we already did disposition of what evidence that she presented, and I asked if there was any other witnesses on the list that she has within the documentation that she gave me. She declared no in the courtroom in front of the judge. She has one witness, and that is the detective who depicted what happened during those events.
So I'm assuming, sir, you're referring to the preliminary hearing when a witness was called?
Yeah,
Okay,
I asked for all witnesses to be there. They never showed.
well, it's not required that all witnesses be at a preliminary hearing, but you do have a right to request witnesses of your own or issuance of subpoenas. I don't get the sense that you did that. Did you file a request for subpoenas?
I did actually CCTV from the jail versus body worn camera, without using their.
Sorry, subpoenas for testimony. Did you subpoena witnesses?
Did I?
Yes.
No, just the CCTV, just wanted the CCTV, that was it.
Okay.
The
There's a
circuit television that they have for security.
There's a process, sir, to request subpoenas issued by the court.
Yeah.
So I would encourage you to
When, where,
to look at the rule, because you have to make a specific request of the court for the court to issue subpoenas, okay?
Well, yeah.
All right.
It's declared in their complaint, security, so. and
But-
it automatically should be CCTV, video should already been entered.
The issue about how many witnesses the people call at the trial itself is not limited by the number of witnesses they called at preliminary hearing. There are requirements for disclosure of witnesses. The people are aware. You should be aware, sir, you have the same requirements for disclosure, but assuming those are all done timely, the people can determine how many witnesses they want to call at trial. Same for you.
Same disclosure for the employees of the jail.
I don't know who they're going to endorse, so I would just make sure that you keep an eye on any pleadings that might get filed, okay? Does August 24 or October 19 work for trial?
October.
I would prefer the October date, so.
Okay, we're going to set a 4-day jury trial for to begin October 19 of this year. How many jurors do you think?
I think, does the court have a standard panel number?
My standard panel, unless there's something kind of triggering, would be 45, but maybe 55 would be
I was thinking somewhere 55, 60, so.
60. Mr. Neely, do you think 60 jurors would be appropriate?
I'm not the one requesting the trial.
Okay, court will request 60 jurors. Mr. Neely, your bonds continued to all of those trial dates, and if it goes beyond the 4 days, your bonds not going to set a pretrial conference at this time. I'm going to leave that till the disbone motions hearings date, and you guys can talk with Judge Moses about the setting of a pretrial conference. Does that work?
Judge Moses.
Judge Moses. So I'm just covering Judge Moses's docket today, but your case is assigned to 5D and Judge Moses, okay? That's when your bond returns are to that courtroom, okay?
Is there any additional thing that I would need to do for transcripts of prior courtrooms for this?
Yes, transcript requests have to be done on form. You can go to the clerk's office again. They can give you a copy of the transcript request form, and there are instructions on the form itself on how to make those requests. Okay, does that make sense?
Yeah, so what time, October 19th?
October 19th, 8:30, every day for trial, unless Judge Moses otherwise says differently, begins at 8:30. She doesn't start at 8 or something different, does she?
I think she starts at
It's 8 a.m. the
8:30.
first day, every subsequent, for jury selection at 8:30 the subsequent days.
Okay, sir, I'm going to modify the bond return dates for October 19th. It's an 8 a.m. return date time. For the remainder of the trial, it's 8:30 unless Judge Moses says something different. Okay? Any questions on that? Okay, and then finally, I did receive, or the court did receive, a summons and complaint. Ms. Lilly, can I request that you approach? I did print a copy for Mr. Neely. Mr. Neely, I'm going to hand you a copy of what was filed in the court record. This was a filing made by Pretrial Services. Pretrial Services is the supervising agency regarding your bond.
The judge only declared on the bond as I have it written.
Hold on one second, sir. I want you to see a copy of this. Have you already seen a copy?
Oh, pretrial supervision was never stated in the courtroom by that judge.
Okay.
What were the conditions? On the bond that I have, there's no time and date for any of these court schedulings for pretrial services.
Is there someone from pretrial on for this case?
Good morning, Your Honor. This is Madeline with pretrial.
Thank you.
All right, sir, have you had a chance to review that summons and complaint?
Yes, they have asked to remove the pretrial services.
That is the request, as I understand it. I can tell you, did confer with Judge Moses on this. The request is based on your non-compliance, but because you haven't picked up any new charges, Judge Moses, and through me, is going to deny the request. She wants you to remain on pretrial supervision, and she wants you to be checking in with pretrial.
Good.
Those dates on that report were not court appearance dates. They were dates to appear with pretrial services.
Yeah, I'd never received any of those dates before.
Okay, so what I'm going to ask, sir, is that you report to pretrial today. If you want to see, there's a card, there should be a card under there. Probably any of them. Sorry, under the podium. Can someone help out?
Which one do you need, Judge? I apologize.
Anyone, I just need to give them the address to pretrial. Please make sure that you give them accurate contact information for you, because it sounds like they haven't been able to reach you.
Can't the court just update it?
No, you need to give it to them. And
I haven't
you
been
need,
convicted of anything. Why do I have to? I'm not trying to be rude or disrespectful or anything. I'm still understanding this whole probation part too. I just showed you the bond that I have. This is the bond that was issued. Would you like to read it? It has nothing to do from the judge about being on supervision.
sir, you don't need to talk to the DA, okay? I'm trying to explain it to you.
Okay.
The condition of bond was that you be supervised by pretrial services. That's contained in the court's record in county court when your bond was set. So those terms and conditions were set in the county court. One of the terms and conditions was supervision through pretrial services. It sounds like they don't have maybe good contact information for you because you've indicated you never got any notice of any of these dates. That's fine. To fix that, I'm going to order that you report to pretrial services today before you leave downtown. Please make sure that you give them current, accurate contact information so they can reach you going forward, and then comply with any other terms and conditions. Pretrial services can go over those terms and conditions with you again, because it sounds like you're saying you didn't have notice of those. All I can see is that those were ordered by the county court, okay?
Do you have an indictment from the county court then?
I think it was a complaint and information. It was not an
Still going
indictment.
off a complaint on
Am I right?
felony
You're
crime?
correct. It is a CNI.
Or an 88 days
That
later?
didn't come with discovery,
Nope.
the CNI?
Hmm?
The CNI didn't come with the discovery?
It should have. He
I haven't
certainly would
received
have
one
the.
paper from the clerk.
Not the clerk, sir.
He should have a copy of the complaint and information. It was also amended to reflect his name, Mr. James Curtis Neely III.
Okay.
And that was given to
Yeah.
him.
Copy of that then?
Can I have you give that to him
Of
now?
course,
The
yeah.
original, and if there was an amended.
Of course.
Sir, I will get you a copy, the DA will give you a copy of that here in the courtroom today. All other discovery you can obtain through the district attorney's office discovery process. Again, records contained in the court file can be obtained by the district, or I'm sorry, in the Denver District Court's clerk's office. And then terms and conditions of your pretrial supervision, you can go over with your pretrial supervising officer.
All filings have to be within the district clerk, you're telling me, correct?
I'm sorry, can't hear you.
All filings must be done in the district clerk's office, right?
Filings that go to the court, yes.
Service of copies then?
Pardon me?
Service of copies?
You
How's
do
that
need to
work?
serve a copy on the opposing party, yes. Was that
Any of your filings, you must, if you have any of them that you're going to issue, can you please send me a copy? Just give it to the clerk.
That's why, sir, that's why we got your address.
The neutral part of, it's an Ohio address.
How are you going to get your mail?
Came out here to report my earnings and then this is what happens.
How are you going to get your mail if everything's being sent to Ohio?
I'll have to send it to me out here.
Who?
UPS, FedEx, do a destination drop off. Get a post office box or use a post office box.
Sir, we need to have some way to send you court orders. The DA needs some way to
Send them
send
to
you.
the address that I gave you. Just send them to the address that I gave you.
And that's Ohio, is that right? Okay. And you can get that address for us. It'll be updated in the court file, but we'll get it. You can grab it from us as well.
Okay, thank
Keep
you.
in mind, sir, if there's going to be a delay for something like that, if you're having your
I'm
mail.
in contact with the people that are there every day, almost.
Okay, let me finish. There's going to be a delay. If we issue a court order or if the people make a filing, those will be mailed to the Ohio. So if that's going to cause a delay, you just need to be aware because sometimes there are requirements for timely responses. If you do update your mailing address, you need to report that to both the court, pretrial services, and also to the people. You can file a notice of contact information change. But until then, all pleadings and court orders will be going to that Ohio address, okay?
As soon as the mail gets there, I'll be notified. Three to 7 days, 3 to 10 days. It's normal.
3 to 10 is
Well,
quite a
it's 3
bit of
days
time.
been mailing, so you have 3 days regardless of wherever you go. If it's federal, I mean, you can go across. Yeah, see, that's not my full legal name. Yet again, you're trying this. James C. Neely. You have a copy of my birth certificate, James Curtis Neely III.
Okay,
Here is
sir,
the James C. Neely.
if you want to file a motion, you can file a
Okay.
motion.
And just to be clear, we did serve you with
Theft,
both
fraud,
the
forgery of a passport.
initial complaint as well as the amended complaint, and the amended complaint should have your correct name.
Okay, thank you, Ms.
I
Lynn.
have right here in her handwriting where it says
All right,
James Curtis Neely
pretrial,
III.
I'm sorry, Ms. Wilson, you didn't get a chance to speak. I'm just going to let you know Judge Moses wants him on pretrial services, so he should be coming to see you right after he leaves court today.
Thank you, Your Honor.
Thank you. Is there anything further?
Different case. Or...
Not from the people. Thank you, Your Honor.
Mr. Neely, is there anything else you wanted to address today?
She had him updated with the clerk, with the county.
Sorry?
The county judge, James Curtis Neely III, as my birth certificate and social security card read for full legal name of indictment. You're still going with this James C. Neely for a civil tort within Burns National against the surety of this bond for your Axon.
Is there anything further you wanted to address today, Mr. Neely?
Plea of innocent. That's it. That's it. I'll see you in July. How's that? Good?
Yes, thanks,
Off the
sir.
record, everything? We're off the record.
We're not off the record, but your
As soon as I
case
walk out of
is,
this room, I'm off the record, correct?
we're done with your case.
Yeah, yeah.
I don't
I'll
know
be
if-
off the record completely. This whole court
I
docket.
don't know whether you're going to be on anyone's record, but you need to
So
report, you need to.
Flock Axon is not going to be, trying to do this whole license plate felony.
I have no idea, sir.
investigation or anything.
They may.
Investigator?
They might.
Are they going to be using Axon still? I'm going to need a warrant for that, for the telecommunications.
You can file a motion, sir.
I don't, they have to.
Okay. Go to pretrial. Okay, thank you.
This hearing never decided whether James Neely was guilty or innocent of the underlying criminal allegations. Instead, it focused on procedural issues that determine how the case will move toward trial. Throughout the proceeding, Neely challenged the way his name appeared in court records, questioned discovery, discussed warrants, bond conditions, and pretrial supervision, while repeatedly insisting on his own interpretation of the legal process. Judge Demetria Trujillo consistently kept the hearing focused on scheduling, filing deadlines, discovery procedures, bond compliance, and the upcoming jury trial rather than allowing the discussion to drift into issues that would be decided later in the case. By the end of the hearing, future court dates had been scheduled, motion deadlines were established, the existing bond conditions remained in place, and the case was officially set on the path toward trial. If you found this courtroom exchange as fascinating as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.